Today, I've got 5 key and mostly hidden truths about the history surrounding the Bill of Rights. I know you're not going to be surprised to hear this, but most history about the Constitution that we're taught distorts or completely skips over key parts of the story, the result of which causes us to often look at it differently than how we should today. The Bill of Rights, of course, is no exception to what I think is a rule. From the reason the Federalists opposed it, to James Madison's flip-flop, to the totally ignored and forgotten preamble to the Bill of Rights, and more. Once you learn about these, I think it just might change the way you view the Bill of Rights today. But first of all, before getting to that, welcome and thank you for joining me here on the Path to Liberty. My name is Michael Bolden with the 10th Amendment Center, and this is the show for Wednesday, October 2nd, 2024. And let's kick it off here. On October 2nd, 1789, following directions approved by a resolution in Congress, President George Washington sent a short letter along to the state governors along with 12 amendments that had been proposed by Congress so the states could consider them for ratification. Here's how Washington put it. In pursuance of the enclosed resolution, I have the honor to transmit to your excellency a copy of the amendments proposed to be added to the Constitution of the United States. I have honor to be, with due consideration, your excellency's most obedient servant. That's what had me thinking about so many of the things that we're not taught about the Bill of Rights, the debate over the ratification, or why it was even considered in the first place. So with that, here are the top 5 facts that I believe that most people really never learn in government-run school. Not in any particular order, but first of all, the Federalists, the people who advocated for the Constitution, they were the ones who didn't want it. They thought it was superfluous, and some of them even thought that adding it would be dangerous. And the debate about this, we can go back to the Philadelphia Convention. Near the end of it, September 12th, 1787. That's the day that the Committee of Style, I believe, presented, I guess it's a second draft of the Constitution, like a 4-page draft. So there was some debate over what was going to be in it or not. And then we get to this from Mr. Williamson, I think it's Hugh Williamson of North Carolina, observed to the House that no provision was yet made for juries in civil cases and suggested the necessity of it. Elbridge Gerry urged the necessity of juries to guard against corrupt judges. He proposed that the committee last appointed should be directed to provide a clause for securing the trial by juries. So with that in mind, because people are saying there's stuff that's missing, and we're talking about one of these essential rights and privileges, the right of trial by jury, George Mason decided that this was a good opportunity to mention a Bill of Rights. He said he wished the plan had been prefaced with a Bill of Rights. And he would second a motion if made for that purpose. He said it would give great quiet to the people. He was recognizing that many people would want one on there. And he said, and with the aid of the state declarations, a bill might be prepared in a few hours. This wasn't something that was going to take him weeks to come up with. Of course, everyone knew that George Mason was the prime drafter of the Virginia Declaration of Rights, which was copied by so many others in so many areas, and still is in many ways today. So Mr. Gerry then concurred in the idea and made a motion for a committee to prepare a Bill of Rights. Mason seconded it, but it was Roger Sherman who actually he was the first person to say something like, we don't need this. He said he was for securing the rights of the people. That's where requisite. He said the state declarations of rights are not repealed by this Constitution and being in force are sufficient. The general message, as we'll see here in a moment, is that, well, these things, the federal government isn't going to be authorized to violate any of these rights that we're talking about in the first place, so why add it on there at all? The state declarations of rights, they weren't in every single one. He said that's sufficient. So there was this motion put up by Elbridge Gerry, seconded by Colonel Mason, to have a committee put together a Bill of Rights on September 12th. It was unanimously voted down. No one was in favor of it, other than maybe just these handful of people. Massachusetts, I guess, abstained, but there was not a single yes vote to even have a committee to draft one in Philadelphia. So then 2 days later, Edmund Randolph, who was one of the 3 that refused to sign the document in Philadelphia, along with Gerry and Mason, he made a motion importing, quote, that amendments to the plan might be offered by the state conventions, which should be submitted to and finally decided on by another general convention. So Edmund Randolph, who became the first attorney general under President Washington, a highly respected legal mind, he was the guy who proposed the Virginia plan at the beginning of the Philadelphia Convention, the big government plan. And he's saying, like, look, I'm not a fan of what we have here, so we should just put in this that the states can propose amendments. We'll have a second convention, hammer out all the differences, and work it out there. He said, should this proposition be disregarded, it would, he said, be impossible for him to put his name to the instrument. Now, he did leave it open that he might change his mind during the ratification debates based on political circumstances, but at this point, he was not on board. He did flip eventually. So George Mason seconded that and said, talked about the dangerous power and structure of the government, concluding that it would end either in a monarchy or a tyrannical aristocracy, which he was in doubt. For one or other, he was sure. So Randolph's motion was also unanimously defeated. So we had two efforts near the end of the Philadelphia Convention, one on September 12th to at least draft a Bill of Rights, at least draft it. Maybe if we don't like it, we vote it down. That was total no. And then to suggest to the states that, well, they can add amendments, and that was voted down as well. The Federalists did not want any amendments to the system. And in fact, right at the beginning of the debates over ratification, it was probably Alexander Hamilton who wrote two essays under the name Caesar of all people, who basically said in those first two, and then they had to tone it down a little bit because it was really creating a lot of opposition, basically said, take it as it now stands. As it now stands, or you're going to get it at the barrel of a gun. So it was a threat to say, as it now stands, you must have it. And many of the Anti-Federalists, just as a quick aside, a lot of their opposition, some people were just opposed to it completely. Some were kind of conditionally on the Anti-Federalist side, basically saying that they opposed it as it now stands. They wanted to see changes. So right out of the gates, there was a debate after the Philadelphia Convention was done. That was September 17th. We call it Constitution Day. So there was a debate. Why doesn't this thing have a Bill of Rights? And James Wilson on the Federalist side really led the charge and set the tone to explain why they felt it was a bad idea to include it. Here he is in his State House yard speech, probably, in my mind, one of the most influential Federalist arguments in favor of the Constitution. It basically was the playbook that was followed by almost everyone after that. The Federalist Papers were nowhere close to as influential as Wilson or Tench Coxe or John Dickinson. But anyways, Wilson put it this way. When the people established the powers of legislation under their separate governments, they invested their representatives with every right and authority which they did not in explicit terms reserve. TLDR, the state governments, James Wilson has explained, this is one of the top legal minds. He ended up being one of the first associate justices of the Supreme Court, nominated for that by George Washington. His lectures on law were very widely read in the early 1790s. So he's basically saying, like, all the state constitutions were set up in this way that if you didn't have express carve-outs, then it was assumed or implied that they had all powers that were not withheld from them. He said, and therefore, upon every question respecting the jurisdiction of the House of Assembly, if the frame of government is silent, the jurisdiction is efficient and complete. So as long as they don't say, you can't do this, you can do anything. But, he said, in delegating federal powers, another criterion was necessarily introduced. We think of this as just the natural reading of things or how it's supposed to be, those of us who profess to be constitutionalists, because we understand the 10th Amendment really hammered this home, that the federal government is only authorized to exercise those powers delegated to it and nothing more, and everything else is reserved to the people of the states as they determine is best for them in each state. So he said, in delegating federal authority, another criterion was necessarily introduced, and the congressional authority is to be collected not from tacit implication, but from the positive grant expressed in the instrument of the Union. In other words, short version, you can only do what's delegated in the Constitution and nothing more. Period. So the question then becomes for the Federalists is, well, why say you're not authorized to do what you're already not authorized to do in the first place? That's going to create confusion and problems. That's the argument that they made. And Wilson continued. He said, hence it is evident that in the former case, the state governments, everything which is not reserved is given. But in the latter sense, the reverse of the proposition prevails, and everything which is not given is reserved. Now, of course, the Anti-Federalists weren't buying this. I'll get to that in a moment. Wilson continued, this distinction being recognized will furnish an answer to those who think the omission of a Bill of Rights a defect in the proposed Constitution. For it would have been superfluous and absurd to have stipulated with a federal body of our own creation that we should enjoy those privileges of which we are not divested either by the intention or the act that has brought that body into existence. So then he says, for example, the liberty of the press. There's nothing in the proposed Constitution that allows them to restrict the liberty of the press, so therefore they can't do it because it is a document set up of delegated and reserved powers. Don't you understand this? That's basically where he's going. He was far from alone. Tench Cox described this as well as in his Essay of an American Citizen, October of 1787, just a couple of weeks after Wilson. He said, the old federal Constitution, that's the Articles of Confederation, contain many of the same things, which from error or disingenuousness are urged against the new one. Neither of them have a Bill of Rights, nor does either notice the liberty of the press, because they are already provided for by the state constitutions. And relating only to personal rights, they could not be mentioned in a contract among sovereign states. I mean, there's a lot there. I could do a whole episode just on that statement. So he's pointing out that this Constitution is not it's not a Constitution for the people, like one united people and everyone, and it applies to that. He's like, this is a contract, or what Brian McClanahan would call a compact, among the several states, and that states don't have rights. It's about individual rights, and personal rights, he said, are best defended on the state level. That was the argument. And he said, as an example, there is nothing in the new Constitution to prevent a trial by jury. So he's arguing with people who are concerned about the trial by jury, which we saw, for example, at the Philadelphia Convention as well, specifically Gary and Mason and Williamson. I think it seems odd that Hugh Williamson was that one of those three, but I guess so. Anyway, so here's Alexander Hamilton, who takes it a step further, of course, in Federalist 84. He said, I go further and affirm that bills of rights, in the sense and to the extent in which they are contended for, are not only unnecessary in the proposed Constitution, but would even be dangerous. I am no Alexander Hamilton fan, but I think he makes a realistic point here. He said they would contain various exceptions to powers not granted, and on this very account would afford a colorable pretext to a claim more than were granted. So basically he's saying, like, if they weren't delegated the power to infringe on the right to keep and bear arms, your natural right of self-defense, they don't have any power in there anyways. If we add it in there, then it almost is basically creating a scenario that they have more power, or they have a say over what those rights and what those definitions may mean. And in many ways, that is played out today. But anyways, Hamilton said, for why declare that things shall not be done which there is no power to do? Why, for instance, should it be said that the liberty of the press shall not be restrained, when no power is given by which restrictions may be imposed? And Hamilton summed it up with this. He said, the truth is, after all the declamations we have heard, that the Constitution is itself, in every rational sense and to every useful purpose, a Bill of Rights. So in the view of the Federalists, as long as there's nothing delegated to the federal government to do something, they can't do it. And so therefore, reserving stuff beyond basically everything that's not listed there makes it in and of itself, Hamilton argued, that this is a Bill of Rights. So the first one, our first one that most people miss, is the reason why the Federalists were opposed to having a Bill of Rights. Now, next up, we want to talk about some key players. And Anti-Federalists were not buying this argument from the Federalist side. In the days and weeks following the Philadelphia Convention, George Mason, for example, his objections to the Constitution were printed and distributed pretty widely. First on his list, I think it was called George Mason's Objections to the Constitution. We have various publications of this. The one that we'll have linked to in the show notes, I believe, is from October 12th or so. No, we'll have November 22nd. But anyways, different versions. He expanded on them in the weeks that followed the Philadelphia Convention. But the first thing on his list in every draft that I've seen is there is no Declaration of Rights. George Mason was a very influential guy. He's basically the James Wilson on the Anti-Federalist side, and many of the Anti-Federalists basically took Mason's arguments and ran with that. Now, I covered his overall Anti-Federalist objections to the Constitution in an episode that I think you should check out, George Mason versus the Constitution, top Anti-Federalist arguments. But the first thing he said is there is no Declaration of Rights. And despite the fact that other people were not aware that he was actually making proposals in Philadelphia a few weeks earlier to say that let's at least do this, let's at least draft this, this was still very, very popular with the opposition. Now, here's Federal Farmer, just days after James Wilson's speech, because it was very popular and very widely read. Federal Farmer, in his fourth essay, this Anti-Federalist essay, directly challenged what James Wilson and the Federalists then were going to say. He said, "It is said that when the people make a constitution and delegate powers, that all powers not delegated by them to those who govern is reserved in the people, and that the people in the present case have reserved in themselves and in their state governments every right and power not expressly given by the federal Constitution to those who shall administer the national government." He said, "It is said, on the other hand, that the people, when they make a constitution, yield all power not expressly reserved to themselves." I'm not sure if it qualifies, but Federal Farmer is almost making a steelman argument. He's basically taking their best argument and then now refuting it. His refutation is this: the truth is, in either case, it is mere matter of opinion, and men usually take either side of the argument as will best answer their purposes. Just a quick aside, in my reading of the Federalist versus Anti-Federalist debate, I think the Anti-Federalists were better at discussing things in the perspective or context of maxims of human nature, rather than saying this is how things can work on paper or in theory. Like if you ever watch the film Oppenheimer, there's a lot about how, principles and theory on paper only go so far. And then maybe when you put it in practice, it plays out differently. And I think the Anti-Federalists had a really interesting approach on this as well, because he's saying, look, okay, this may be the case, but ultimately, the people in power, the way they read it, that's what we have to be thinking about. And we can't just think about it in regards to tomorrow. We have to think about it for the future as well. And he said, in either case, it's just a matter of opinion. Those people with power are going to read it in the way that advances their purposes. And if we understand the maxim that government power always grows and human beings are flawed creatures and the worst of the worst will be drawn to the most power, well, this is a really bad potential cycle. Patrick Henry in the Virginia Ratifying Convention also hammered on this position from the Federalists, starting from Mr. Wilson. And he said, "The necessity of a Bill of Rights appears to me to be greater in this government than ever it was in any government before." Patrick Henry was no dummy. He heard the arguments. I'm sure it made logical sense to him. But he's saying, look, this is novel. This is something new. We've never actually had a government like this before. Mr. Wilson himself, and there were people who actually wrote Anti-Federalist essays that specifically were addressed to Mr. Wilson, at least the arguments in the essays. He's saying Mr. Wilson is basically telling us all the other constitutions have been the other way around, and now we have this new one, and doesn't say it in there specifically like we had in the Articles of Confederation. So we got to just trust this? And Henry put it like this: "I repeat, that all nations have adopted this construction, that all rights not expressly and unequivocally reserved to the people are impliedly and incidentally relinquished to rulers, as necessarily inseparable from the delegated powers. So Henry's pointing out, agreeing with Wilson, that everything else previously was the other way around. If it wasn't expressly carved out, they could do whatever the heck they wanted. And he's like, well, where does that leave us? And Patrick Henry continued with this. He said, this is the question. If you intend to reserve your unalienable rights, you must have the most express stipulation. For if implication be allowed, you are ousted of those rights. If the people do not think it necessary to reserve them, they will be supposed to be given up. And then he points out, just like I was mentioning a moment ago, that there was a clause, Article 2, in the Articles of Confederation. You didn't have to list out exactly what it said because everyone knew that in the Articles of Confederation, it specifically said if it wasn't expressly delegated to Congress, then it was reserved to the states and the people. So he's pointing this out as well. He's like, okay, this may be the case, but why can't we just have this text in this document? Are you trying to scam us? I think maybe he smelled a rat, I guess. It was expressly declared in our Confederation that every right was retained by the states respectively, which was not given up to the government of the United States. But there is no such thing here. You therefore, by a natural and unavoidable implication, give up your rights to the general government. So in short, this whole debate, the opposition by the Anti-Federalists, is really a 10th Amendment debate. Now, the 10th Amendment didn't exist, but it's about what is delegated and reserved. And for many of the Anti-Federalists, we know that as long as it was spelled out that they could only do those things that were expressly delegated in the Constitution, then everything was going to be cool. But without that, they expected, as Federal Farmer and Patrick Henry and many others actually said, was that by implication, they're just going to do whatever the heck they want, or they're going to be the ones to define the limits of those rights if there are any, which they're not. So, and that's why I think John Hancock is so important to the story, the history behind the Bill of Rights, and probably why we don't hear about him in relationship to the Bill of Rights at all. This is just almost completely ignored. Now, from my understanding, shortly after the Philadelphia Convention in the fall of 1787, Hancock was already drafting personally some amendments that he wanted to see. He's governor of Massachusetts, very popular guy. He was one of the two people in 1775, just a couple of months after not even 2 full months after the fighting broke out at Lexington and Concord, one of 2 people that General Gage said, we will not give a pardon to, even if everybody gives up their guns and everybody stops fighting and bends the knee. Doesn't matter. Samuel Adams and John Hancock will never qualify for this. We are going to take them back to the mother country and they are going to be punished. So this is a really important dude from the Revolution. And so he was drafting some amendments that he wanted to see. And by January of 1788, when the Massachusetts Ratifying Convention was meeting, the Federalists were doing vote counts. They were basically they were polling delegates to see, well, are we going to win? And from my reading of this, and also Pauline Mayer's great book about ratification, she discusses it in some more additional detail. Federalists knew they were going to lose. They were basically going to get smoked in Massachusetts, and still had, I believe, New York, Virginia, New Hampshire. So if Massachusetts voted no, the odds of what became a very close vote in some of these other ones would have probably been no. This would have doomed the whole system. And so they were really concerned. So they went to John Hancock specifically, and they made a deal. And I'm not sure who initiated. Was it Rufus King and Theophilus Parsons on the Federalist side? Or was it John Hancock and Samuel Adams on the Anti-Federalist side? Everybody knew that these guys wanted some amendments, even though Hancock had not been attending. He was sick. But so they made a deal to ratify in Massachusetts with proposed amendments. And the first on the list of the amendments proposed by Massachusetts was a precursor to what became the 10th Amendment about delegated and reserved powers. And then from there, we ended up having very similar text to that in South Carolina when they ratified, in New Hampshire when they ratified, in Virginia when they ratified, and in New York. So they all decided to follow the lead of Hancock and Adams and Massachusetts and say, okay, we'll ratify as long as you make a deal that this is what's going to happen when we go forward in the first Congress. And so here's Thomas Jefferson discussing this. He wrote a few letters that mentioned this. And in fact, he had been writing to James Madison, trying to encourage him to support a Bill of Rights. And Madison, in the fall of 1787, was not on board. And so once Madison heard about the plan of Massachusetts, Governor Hancock's plan, he started talking it up. He's like, this is the way to go. Of course, he was in France, but he was still very influential on the ratification debates. And here he is in a letter to Edward Carrington. This is one example of a few with this same message, May 27th, 1788. He said, my first wish was that 9 states would adopt it in order to ensure what was good in it, and that others might, by holding off, produce the necessary amendments. And Jefferson's goal for an amendment was an express declaration, specifically declaration that those powers not delegated are reserved to the states and the people. So he was a 10th Amendment guy. He eventually called the 10th Amendment the foundation to the Constitution. So his idea was a political strategy. Okay, we don't want to start from scratch here. I like a lot of what's in here. So the ones that have ratified, that's great. But there's 4 more to go. They should all say no. And that will force an amendments convention or a second convention to be able to add amendments. Or maybe they do it in Congress. I'm not sure. He said, but the plan of Massachusetts is far preferable and will, I hope, be followed by those who are yet to decide. So Jefferson is basically saying, this is the way to go. We make a deal. We recognize that we all fought this revolution together. And this, although there may be factions developing and differences, this is the way forward. We're going to recommend amendments and they better follow through. And everyone knows that they better follow through or there's going to be a problem. Now, this will be linked to in the show notes. This and all the original source documents that I'm mentioning, the other articles, episodes, etc., they'll all be in the show notes. Alan Mosley does such a great job getting those organized for every single episode, and I get them published about 2 hours after the live stream is done. Sometimes it's a little bit earlier, but basically a blog post for every episode over at 10thamendmentcenter.com/path to liberty. And basically, for each blog post, you're going to find a section at the top that gives you a quick overview, then an audio player for the podcast and various podcast platforms, a video player, and then all the other video platforms. But just scroll down and you'll see show links. So you can be like, Bolden, where was that letter from Jefferson to Carrington talking about this plan of Massachusetts? Well, you're going to find a link to it there so you can read in context and learn more on your own time. And while I'm here, I want to take a quick moment to say hello to everyone out in the live chat. I appreciate you being here. Whether this is your first episode or you've been here for every single one since day one, there's Kirk Morrison. Good to see you, buddy. Cheriton Farmer. Diana, great to see you as well. Howard. Tyler B, it's been a while. Dan, Cosmic, Lynn, Sonny Bono, Haji, Melody, and a bunch of other people. I know I'm just kind of scrolling through, but I really want to get back to this info because there's plenty more to go. I appreciate you being here. Again, the blog post, 10thamendmentcenter.com/path to liberty, coming in a couple of hours so you can follow along with these source documents and learn more. So number 3 we're going to get to is James Madison's flip-flop. Madison was a big government guy. He wanted a much bigger government than they came up with in the Philadelphia Convention. I think in many ways, Madison was a rare creature in that he wanted more, but he was willing to support less and argue in favor of what they actually passed, rather than the Hamiltonian approach, who wanted more and then, well, just lied about things later on. But Madison was definitely not a fan of the Massachusetts plan. So Jefferson was like, this is the way to go, but Madison was not a fan of it. Here he is in a letter to George Washington, February 15th, 1788, just about a week after John Hancock gave a speech in support of ratification, and then they barely ratified. And Madison said, I have at length the pleasure to enclose you the favorable result of the convention at Boston. The amendments are a blemish, but are in the least offensive form. So he thought there was a blemish. He, like the other Federalists, did not want to see amendments at all. He wasn't even in favor of them. But at the same time, well, we know that Thomas Jefferson ended up helping convince James Madison that a Bill of Rights was absolutely necessary to go forward it. A big part of it was also recognizing the political consequences if Madison did not support it, because Governor Patrick Henry, in essence, was doing gerrymandering before that was actually a term. And so he personally wanted to see no more big government people from Virginia getting into Congress now that the thing was going to go forward. And so he made sure on the Senate side that Madison didn't win. He nominated two people. Of course, Patrick Henry was incredibly popular. And so Richard Henry Lee and I believe William Grayson beat Madison. Madison still got a respectable amount of votes because there was a Federalist contingent there. But Patrick Henry, Governor Henry's push for this made sure that Madison didn't make it on the Senate. So then he was convinced to run for the House. And there wasn't a lot of electioneering back then. And Patrick Henry, I think, was involved, had his hand in some redistricting. And the idea was that if Madison's district was going to be in a Federalist stronghold, then he would absolutely win, probably go unchallenged. But it was redistricted, it was drawn in a way, not redistricted, but it was drawn in a way that he had a challenger, James Monroe. And from my understanding, this is the only time two future presidents ever went head-to-head in an election for the House of Representatives. So that's pretty fascinating as an aside. But Madison was recognizing that if he didn't flip his story and start saying, because they were out there, and the Baptists, for example, were strongly pointing out, oh, James Madison is against your right of conscience because he does not want it in a Bill of Rights. And so he was probably going to lose to James Monroe, so he had to take this position. So I'm not sure how much he was convinced, as many of the people say, and I even just said, by Thomas Jefferson, because Jefferson said, Bill of Rights is what everyone is entitled to. You should be able to have this. And Madison is still not totally convinced. But where he really flips the switch is when he's probably going to lose his race for the House after he already lost a potential nomination or a potential win by the state legislature for the Senate. And here from Montpelier.org, they write, while this would probably be characterized as a flip-flop today, Madison had reasons for changing his mind. During the Constitutional Convention, Madison had not felt the need for a Bill of Rights on a national level, believing that the people's rights were fully protected by each state through documents like the Virginia Declaration of Rights, which was drafted by George Mason. The ratification process, however, had opened Madison's eyes to the fact that we, the people, cared very much about adding a Bill of Rights to the Constitution. He still was not on board, at least the way I'm reading it. Maybe someone else will correct me on this, but I think he really didn't get on board with pushing for this until it became obvious that he wasn't even going to win in the House of Representatives. So he wrote a letter to a very influential guy to see if he could get an endorsement and basically correct the situation, or at least get Madison's not opposed to the rights of conscience. And this is a letter to George Eve in January of 1789. He said, I freely own that I have never seen in the Constitution, as it now stands, those serious dangers which have alarmed many respectable citizens. Accordingly, whilst it remained unratified and it was necessary to unite the states in some one plan, I opposed all previous alterations. And his reason was, he said, they were going to throw the states into dangerous contentions, furnish secret enemies of the Union with an opportunity of promoting dissolution. So the argument from the Federalist side, whether this is just hyperbole or not, was if we don't take it as it is, everything's going to be chaos. But now Madison said, circumstances have now changed. Well, I'm running for office. Maybe that's what it is. Amendments, if pursued with a proper moderation and in a proper mode, will be not only safe, but may serve the double purpose of satisfying the minds of well-meaning opponents and of providing additional guards in favor of liberty. So maybe he is recognizing, look, if I don't get on board with this, not only am I going to lose, but there is really a fight brewing. And we promised all these people in Massachusetts and New Hampshire and South Carolina and Virginia and New York, all these people were promised that we were going to consider amendments. So I better get on board. And I think there is some honor in his flip-flop as well. And Madison continued, under this change of circumstances, it is my sincere opinion that the Constitution ought to be revised, and that the first Congress meeting under it ought to prepare and recommend to the states for ratification the most satisfactory provisions for all essential rights. So Madison ended up being a ghostwriter for George Washington's first inaugural. I don't think they used the term back then, and we don't 100% know how much of this he wrote, but he certainly had a hand in writing Washington's inaugural and kind of moderating some discussion about amendments. And Washington actually authorized it. So this is Washington's take as well. Besides the ordinary objects submitted to your care, this is to Congress, It will remain with your judgment to decide how far an exercise of the occasional power delegated by the fifth article of the Constitution is rendered expedient at the present juncture by the nature of objections which have been urged against the system or by the degree of inquietude which has given birth to them. So he's basically saying, like, all right, it's up to you, Congress, to make the decision, but maybe we should go with this. He said a reverence for the characteristic rights of freemen and a regard for the public harmony will sufficiently influence your deliberations on the question how far the former can be impregnably fortified or the latter be safely and advantageously promoted. In other words, you guys got to consider some stuff. In fact, there was an earlier draft that had listed out a bunch of recommended amendments, and it was Washington and Madison that just kept it kind of general and left it to Congress. Defer to Congress. And Madison did keep his promise. He was very active in pushing the Bill of Rights through the first Congress. And if it wasn't for him, we probably wouldn't have it. So he did flip-flop and then followed through. It wasn't just political grandstanding. And number 4 that we're getting to on this list of forgotten truths, forgotten history, is the preamble. Now, while we're all probably familiar at least with the preamble to the Constitution for the United States, the big we the people, few people even know that there ever was or is a preamble to the Bill of Rights. And that preamble tells us about its origins, which you've already heard a bit about, and the reason it exists. And in fact, when I did some research on this yesterday for my notes, I was digging through web searches, and I'm looking for preamble to the Bill of Rights. There's very little writing or videos or anything discussing it. And in fact, some of the top results are things like a question and answer websites like Quora, where you find the most popular response from an educator says there's no reason to even teach people that there is a preamble to the Bill of Rights. It's a waste of time. There are other things that we can talk about when it comes to the Constitution, and this is pointless. But it isn't pointless, and here's what it has to say. The conventions of a number of the states, having at the time of their adopting the Constitution, expressed a desire, in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added, and as extending the ground of public confidence in the government will best ensure the beneficent ends of its institution. So, in short, the preamble to the Bill of Rights confirms a number of things for us. First of all, there were a number of states that were concerned that the new federal government, the general government, was going to have too much power, or that the powers delegated were not clearly defined. And that's why at the top of basically everybody's list, or right near the top, was a precursor to the 10th Amendment about delegated and reserved powers. And then 2, the proposed amendments from the first Congress were in response to the promises and deals made at the state ratifying conventions. And in other words, the amendments were a list of declaratory clauses. We have that, the 9th and 10th Amendment, that clarified the overall limits of federal power. We call them a legal rule of construction. And then we have restrictive clauses, which are the first 8 amendments, and those limit federal power. It was only after judicial interpretation of the 14th Amendment in the early 20th century that the Bill of Rights was ever thought to apply to the states. So the Bill of Rights originally was either restrictive clauses on the federal government or declaratory, clarifying how to read the document in the 9th and 10th Amendment. So it was only through something called the incorporation doctrine, which was a judicial interpretation of the 14th Amendment in the early 20th century, where the Bill of Rights was thought to apply to the states, and it did so only selectively over time. I covered the incorporation doctrine in another episode, really trying to give just a basic overview of what that is. That'll be linked to in the show notes as well. And then number 5 on this list are a few things that did not make it. So James Madison, in his speech proposing or introducing amendments, this is in June of 1789, it didn't take him too long to get to work, he had a number of proposals that did not make the cut, like applying amendments to the states. For example, he said, the words, no state shall pass any bill of attainder, ex post facto law, etc., were wise and proper restrictions in the Constitution. So he's pointing out that there are some things that he thought were right to restrict the states from doing, and that was listed in the Constitution. But he said, I think there is more danger of those powers being abused by the state governments than by the government of the United States. The same may be said of other powers which they possess, if not controlled by the general principle that laws are unconstitutional which infringe the rights of the community. So he made a proposal to have some of what became the Bill of Rights apply to the states, and it was rejected. He said, I should therefore wish to extend this interdiction and add, as I have stated in the 5th resolution, that no state shall violate the equal right of conscience, freedom of the press, or trial by jury in criminal cases, because it is proper that every government should be disarmed of powers which trench upon those particular rights. Another thing that Madison tried to include was a kind of a preamble. He wanted to affix some text before the "we the people." And he said, first, this was his first recommended amendment, that there be prefixed to the Constitution a declaration that all power is originally vested in and consequently derived from the people. This comes straight out of the Virginia Declaration of Rights, 1776, the Virginia Revolutionary Constitution from George Mason. And this was a very popular thing. It is all over the place in state constitutions. And I think Madison was recognizing this as an important principle. He was part of that as well. And then he wanted to add that government is instituted and ought to be exercised for the benefit of the people, which consists in the enjoyment of life and liberty, with the right of acquiring and using property, and generally pursuing and obtaining happiness and safety. Good on Madison to include some principles from the Declaration of Independence, because that's the whole precursor to all of this. And he said that the people have an indubitable, unalienable, and indefeasible right to reform or change their government whenever it be found adverse or inadequate to the purposes of its institution. So he's really wanting to change just basic "we the people" to telling us what that really means. We, the people of the several states, are the top of the food chain, and so therefore all power comes from them, and government only exists at their request. And the only reason it's there is for the benefit of the people, etc. And they can change it as they need to, or alter or abolish. Now, I think it was Roger Sherman, again, who was one of the first to say, no, we the people says all this, and we don't need to add this as well. Now, I'm kind of a fan of Roger Sherman as well, but that's I wasn't on board with those things. And then he also wanted to include a brand new Article 7, where they would have had one clause clearly defining or listing separation of powers, that this branch can never cross into this branch and this branch can never cross. You can read it in full, of course, because Madison's proposal will be listed in the show notes. And then another in the body of the Constitution in Article 7 that was the first draft of what became the 10th Amendment. So he thought separation of powers and delegated and reserved powers were so important they had to be put together as a new Article 7. I covered that. That was his 16th Amendment, probably much better than the 16th that we have today. I covered that in another episode. The other 16th Amendment, separation of powers. Well, I hope you guys found this interesting and educational. We work really, really hard to get this kind of essential, forgotten, ignored historical information, foundational principles about the Constitution, the American Revolution, about liberty, how to defend it all when government refuses to do so. We work really hard every day to get this information out to more and more people. And nothing helps us do this work more than the financial faith and support of our members. You can join us for as little as $2 a month over at 10thamendmentcenter.com/members. We also have annual, 5-year, and lifetime options. So if you got a couple of bucks of that dirty government fiat that they keep devaluing and destroying, please consider throwing it our way. No one punches above their weight class better than the TAC, and we will use every single penny, devaluing penny, to take a stand for the Constitution and liberty, whether the government likes it or not. They certainly do not. No pressure if you can't join, but again, that's 10thamendmentcenter.com/members. You can also help us out with some free, easy peasy steps like leaving reviews on Apple Podcasts or any other podcast platform, smashing the like, leaving comments in the archive, getting notifications, subscribe. All that stuff can help trigger the algorithms of these mainstream platforms and tell them to show us to more people, and it does help a lot. So thank you so much for being here. I hope you enjoyed the episode, and I hope to see you next time here on the Path to Liberty.